Hi, in our first episode, we explained that a set of people called shareholders will bring in money, that is, equity share capital. So in this episode, let's explore the concept of shareholders. For that, let's take an illustration.
Let's say Mr. A and Ms. B together enter into a business and they incorporate a private limited company, AB Private Limited, with an equity capital of 1 lakh rupees. In the company, 49,000 rupees has been invested by A and 51,000 by B, thereby making their shareholding as 49% and 51% respectively. In this case, both A and B are termed as shareholders. Therefore, a person who infuses equity capital, that is ownership, into the company by way of money and holds shares in such equity capital, as you have just seen in this illustration, A is holding 49% and B is holding 51% of the total capital. Since they hold respective shares, they are called as shareholders. The proof of shareholding is provided by a share certificate, and this shall be in the format specified under the Companies Act 2013, which is Form SH1. Now let's learn something interesting under the Companies Act 2013. As per the Companies Act 2013, all the rights and powers are available to members and not shareholders. So, is there any difference between a member and a shareholder? Well, as per Section 88 of the Companies Act 2013, every company shall maintain a register of members. And as per Section 2, subsection 55 of the Act, the term members is defined as either a subscriber to the memorandum whose name is entered in the register of members, or every other person who agrees in writing to become a member and whose name is entered in the register of members, or every other person holding shares of the company in dematerialized form and whose name is entered as a beneficial owner in the records of a depository. Therefore, only those shareholders whose names are entered in the register of members shall be considered as members for the purposes of Companies Act 2013. Is there a possibility that a shareholder might not be a member of the company? The answer is yes. For that, let's continue the illustration we had before. So in the previous illustration, we know that A has got 49% shareholding in AB Limited and B has got 51%. Now let's assume that the names of both A and B, who are the subscribers to the memorandum, are being entered in the register of members, which means both A and B are members. Now let's say that A transferred his shares to C, but they failed to lodge their share transfer deed with the company, which means the company is unaware of this transfer. Now, in this particular scenario, the register of members does not contain the name of C, even though there has been a valid transfer, thereby C is not a member. However, by virtue of entering into share transfer deed, C has taken the ownership over the shares, thereby making C the shareholder of the company, but not a member.
Hope you liked the video. Do not forget to subscribe Virtualaw for more such interesting explainer videos on company law. In our next episode, we will have an understanding on who are directors. Thank you.